Port Harcourt, I'm Dio. 8 minutes gone past 4 p.m. Conversation continues. Many thanks for staying tuned. And the matter we're discussing right now, controversies regarding the situation with who is a collector, who is legally responsible for the collection of VAT in the country. The Rivers State government has opened what may be a Pandora's box at the moment, and it appears other states are lining up to get a peep as to what's in that box, what's contained. The Lagos State government definitely right behind Rivers State. One imagines it's only a matter of time before other state governments or other states get in line to explore the possibilities. Well, on the other hand, there are states, Katsina and possibly others, for example, who are against this venture and want to keep that box sealed. But in whose favor is the law at the moment is what we're exploring. Now, here's a story, courtesy the cable. VAT judgment maintains status quo, don't panic, FIRS tells taxpayers. A Federal Inland Revenue Service has asked taxpayers not to panic over the recent court ruling by the Federal High Court sitting in Port Harcourt. The court on Monday dismissed FIRS's motion for stay of execution of the earlier judgment directing Rivers State to take charge of value-added tax collection. The agency said, quote, until the Court of Appeal or even the Supreme Court determines the matter, taxpayers are required to continue to comply with their value-added tax obligations within the status quo framework. Now, Johannes Oluwatobi-Wojola, Special Assistant on Media and Communication to the Chairman of FIRS, said this in a statement on Monday. The FIRS have been launched in the Court of Appeal, both an appeal against the decision of the Federal High Court sitting in Rivers State in suit number FHC/PH/blah blah blah, Attorney General of Rivers State versus Federal Inland Revenue Service, and an injunction pending appeal of the said judgment assures taxpayers that there was no cause for alarm. The Federal High Court ruling should not breed any confusion as to the obligations of taxpayers. Taxpayers must continue to comply with the Value-Added Tax Act pending the final determination of the appeal. Taxpayers must continue to honor their tax obligations under the VAT Act. Failure to do this would put them on a collision course with the law. For the avoidance of doubt, records of appeal have been transmitted to the appellate court. The service is confident that given the extant laws, the arguments and case put forward, it will earn a favourable judgment at the appellate court. Meanwhile, Nyesom Wike, Rivers State Governor, has directed the State Internal Revenue Service, RIRS, to fully implement and enforce the collection of value-added tax. The Lagos State House of Assembly also passed the first and second reading of a bill seeking to empower the state government to collect value-added tax. So who is legally responsible for the collection? At least for the moment, I imagine the situation is not beyond the realm of possibility at the moment. It might change, but as at today, who's legally responsible for it? We're joining me via phone for this conversation. Immediate past chairman, Nigeria Bar Association Amok Branch, also Associate Professor of Public Law at the Rivers State University, Barrister Ritchard Wokocha. Barrister Wokocha, good evening to you. Welcome to Hard Facts.
Thank you, Dario, and good evening, Nigerians.
Well, let's get straight to it then. So the FIRS statement says that taxpayers, quote, must continue to honor their tax obligations under the VAT Act. Failure to do this would put them on a collision course with the law. So let's talk about that. Emphasis on collision course with the law. The law. As at today, today is Tuesday. I didn't forget that. Today is Tuesday, September 7. So today, Tuesday, September 7, 2021. What does the law say as regards whose responsibility or right it is to collect VAT in Nigeria?
As of today, based on our constitution, the responsibility to collect VAT or the right to collect VAT rests to the state government by virtue of the decision of the Federal High Court. It's to be understood that the effect of the judgment of the court is that the aspect of the value-added tax, which makes it the federal government prerogative to collect that tax in states, has been declared unconstitutional. Unconstitutional means that it is not in conformity with the dictates and intent of the Constitution. In other words, it's contrary to what the Constitution says should be done. The High Court of a state and the Federal High Court have powers to review the acts of legislation undertaken by the legislature. And having done so, what the position is now is that that part of the act that the FIRS is relying on is unconstitutional. So the law today is that it is the states that have the power to do that. Until that judgment is overturned, if it gets overturned for any reason. That is the present position of the law. So anybody complying ought to comply with the state government law, that is the added tax law, and not the value added tax act.
All right, now
they are within the state.
The FIRS is saying that, I'd like to quote the statement again, for the avoidance of doubt, records of appeal have been transmitted to the appellate court. The service is confident that given the extant laws, the argument and case put forward, it will earn a favored judgment at the appellate court. Now, I believe, simply speaking, what this means is that the FIRS has filed an appeal against the judgment of the High Court in Port Harcourt here. Does that mean that due to the appeal that's been filed by the FIRS, they can still go ahead to collect that until these matters are determined either at the appeal court or even the Supreme Court?
In fact, they speak in contradictory terms. They express the hope that it will end in their favor, which means that at the moment it is not in their favor. The fact that they have transmitted a court of appeal to the Court of Appeal has not in any way affected the judgment of the High Court. The judgment has declared the position of the law, and the only way it can be affected is either that there is a contrary judgment by a superior court, the Court of Appeal, or that there is an order for stay of execution, either by the High Court, the Federal High Court that gave the judgment, or by the Court of Appeal. But until there is such order for stay of execution, the execution of that judgment is not stayed, meaning that the judgment is fully in effect, and the winner of the case is entitled to enjoy the proceeds of the case that he won, until there is anything to the contrary. So it's not enough that they have transmitted records. If that was enough, then there wouldn't have been need for them to file a motion for stay of execution. So the true position, as they say, is that they are hoping that they will win on appeal. But at the moment, they have lost, and the winner is the state government, meaning that after today, under our laws, it's the state governments that have the power to impose value-added tax.
All right, we need to move on to other aspects of this, but let's go back just a little bit. I mean, to the decision of the High Court stating that the River State government, and by extension, other states in the country, are the ones with the right to collect VAT. I'd like to get to your personal, professional opinion on that judgment of the court.
I think what the court was called upon to do is to interpret the Constitution, and if you look at the exclusive legislative list that provides for matters over which only the federal government or federal legislature has exclusive competence, you have on item 59 taxation of income, profits, and capital gains, except as otherwise prescribed by this Constitution. Now, by the principles of federalism, where powers of the center are enumerated, the center cannot exceed what is enumerated, because whatever is left, what is called residual matters, are for the state to exercise. So, you cannot see value-added tax among those taxes here. And for that reason, any other tax that is imposed is a tax that the state should be imposing. Any other subject of tax that is not named in the Constitution should be a residual matter. So I think the judgment of the court, in my opinion, is sound. Perhaps we have not, prior to this time, thought of challenging that fact. But at the moment, that is a residual matter. It's not one that is specifically named in the Constitution for the federal government to impose tax on. Meaning that such tax imposed by the federal government should operate within the federal territory.
Now, back to
So it's a matter about which the state should have competence to make law.
Now, back to the matter at hand. Referencing the statement of the FIRS once again, they're saying that the Federal High Court ruling should not breed any confusion as to the obligations of taxpayers. Taxpayers must continue to comply. Also saying that the service is confident that given the extant laws, the argument and case put forward, it will earn a favourable judgment at the appellate court. Now, I've spoken with different lawyers on this matter, yourself inclusive, and the position appears to be the same, that the Federal High Court's position in Port Harcourt here is the correct one. But in spite of that, the FIRS is still expressing a lot of confidence that it will get the matter ruled in its favor at some point, either at the appeal court or the Supreme Court. Now, in the event that that does happen, as unlikely as it may seem, because I would not want us, and you would not as well, I believe, want us to preempt what the courts will decide eventually. But as likely as that may seem, if it does happen, in the event that it does happen, because, I mean, it is still within the realms of possibility, am I right?
Yeah, you're right.
Okay, so in the event that that does happen, will it make any sense? And these matters could be decided in a matter of weeks, maybe even months. Would it make any sense then for companies, businesses, individuals to thus begin to commit their VAT and possibly other taxes to state government? What happens if there's a reversal of this judgment of the Federal High Court in Port Harcourt?
Well, the FIRS themselves is saying, even though the present position of the law expressed by the court is that we don't have the right to do this, nevertheless, continue to work with us.
Hello?
The court has
Hello?
declared unconstitutional. Yeah, can you hear me?
I wasn't hearing you for a moment.
Can you hear me?
Yes, I can hear you now. Go ahead.
Okay, good. So they cannot urge companies to comply with the law which the courts have declared unconstitutional. If they do so, then that should be even more reason why the company should comply with the law which the courts have declared constitutional and valid. So the proper thing for companies to do is, if VAT payment is due, is to pay to the appropriate agency that the courts have upheld is the agency constitutionally authorized to collect VAT, and not to pay to one who is relying his request, who is basing this request on a law that has been adjudged unconstitutional. That law stands amended. Until there is a judgment to the contrary, that law stands amended. Those aspects of it that offend the Constitution are void. They don't exist. They are not legible. If you look at the law, the eyes of the law do not see those parts, those sections. So they don't exist.
Do the companies
that is to pay VAT now is to comply with the extant law, which is the operative law in Rivers State, if they are operating in Rivers State.
Now, do the companies face a dilemma at the moment as regards who to pay their VAT to? Now, I think we have 2 or 3 different scenarios here. Number one, the scenario is, let's start with the one in Rivers State. The Rivers State government has secured a judgment of court saying that Rivers State government should collect VAT. FIRS is saying no, you must pay to us. So let's look at that as the first scenario. FIRS is still insisting, and the FIRS is representing the federal government. So whether the federal government, and by this I mean the presidency specifically, has issued a statement or not, I think it's safe to say the FIRS is representing or presenting, exactly, is presenting the position of the federal government, and the presidency cannot dissolve itself from that position. So, yes, on one hand, you have the companies maybe torn between two right now. Do we go with the state government or do we go with the quote-unquote almighty federal government? Now, two...
In the eyes of the law, there is only one right at the moment.
Okay, now, also a second scenario, in Rivers State here, we have a Rivers State government law as well that says, yes, pay VAT to us. That law exists right now, standing to law by the governor. Now, third scenario, you have other states who, by the way, are also affected by this judgment of the Federal High Court in Port Harcourt, but do not have existing laws. Lagos State government is in the process of that right now. Besides Rivers State, that has a law already, and Lagos State government that's in the process of getting its own law, I'm not aware of any other state that either has a law or has even initiated the process. So, in those states, that's the third scenario right now, where there are no laws. What are businesses supposed to do there? So, first scenario, whether you're in Rivers State or outside Rivers State, you have the federal government on one hand versus state government. And then second scenario, in Rivers State, there is a law which is similar to first scenario. Which should they go with? And then third scenario, states that don't even have any laws at all.
Laws.
Yes.
Okay, in Rivers State, if they want to be safe, they have to go with the existing law, which is the law of Rivers State. Because the law of the national legislature has been declared unconstitutional with respect to applying to states. Then for states without value-added tax law, companies are not under obligation to pay VAT. A tax is an imposition by law. And so if there is no law yet imposing that obligation, it does not exist. So in those states where there is no value-added tax law, if they desire to do so, it's for them to enact a value-added tax law, pursuant to which they can now levy that tax on entities within their territory and collect the tax. So, but until that is done, the companies have no obligation to pay any tax.
So they may not. They will choose to not. They will not pay to the states, and they may choose to not pay to the federal, to the FIRS as well.
No, they cannot pay to the FIRS because the court has declared that invalid. So they cannot. But they are not under obligation to pay to the state until the state enacts a law to that effect, imposing that tax.
All right. Once again, making reference to the FRSC statement, they said that taxpayers must continue to honor their tax obligations under the VAT Act. Failure to do so will put them on a collision course with the law. Can the FIRS or any other agency of government or institution sanction businesses or individuals, for example, living anywhere, and especially here in Rivers State, for not remitting their VAT to the FIRS?
Such sanction cannot be done anymore because you have to impose that sanction based on a law that has been violated. And as it stands, there is no law violated by a company that fails to pay VAT to FIRS because the law on which FIRS is relying has been declared unconstitutional by the courts, and so is void. Until there is anything to the contrary, you cannot punish a person for breaching a non-existent law. So for those who are in states who are not operating at the Federal Capital Territory, what it simply means is that they are relieved of that tax until the appropriate legislature introduces that tax through a law.
So, back to an earlier question I asked you before we go for a commercial break now. What happens if, in the event, no once again, another attempt to try to determine what the court will decide? We don't know what the court will decide, but like you also admitted a while ago, it's not beyond the realm of the possible. If the court reverses the decision of the Federal High Court here, whether the appeal court or the Supreme Court, and companies are already complying with the River State tax law, for example, the VAT law, and possibly similar variations or variations of it elsewhere in the country, in other states. If there is a reversal, what happens to the amount that has been paid, that would have been paid to the River State government, for example?
I don't think that would be much of a difficulty because the court will have competence to ask one agency or one authority to remit what is wrongly collected to another authority. You recall in the cases of oil wells wrongly attributed to states that do not own them, the Supreme Court did not have difficulty in making orders for money collected or paid to those states with respect to those oil wells to be refunded to the states that validly own them. So I think that is an issue that the court itself can settle.
All right, it's hard facts. 91.3 Nigeria Info in Port Harcourt. VAT judgment maintains status quo. Don't panic. FIRS tells taxpayers. So discussing this development at the moment to Barrister Ritchard Wokocha. Quick break. We'll return in a moment. Conversation will continue. And you're welcome to join via the usual platforms. Please stay with us. Hard facts return shortly.
We connect you to the world. We connect you to the vicinity. We are Nigeria Info.
Listen to me. I said this is a real situation and the government has to do something about it. You try to insinuate all these people looting Nigeria's money. You think
This is Nigeria Info in the heart of Nigeria. 92.3. We are Nigeria Info.
And now, hard facts. Hard facts with Gaio.
Welcome back. 29 minutes ago before 5 o'clock. The news update is up at 5. Before then, discussions continue. My guest still joined me via phone, Barrister Ritchard Wokocha. Barrister Wokocha, you're welcome once again.
Thank you, Dario.
The matter remains the same. VAT judgment maintains status quo. Don't panic. FIRS tells taxpayers. Find details in the cable. You're welcome to join the conversation right now. Comments, questions are welcome. Call the numbers 0817 93 0002 or 0003. Also 0817 93 0007. WhatsApp is on 0809 0306416. We are live on facebook.com/Nigeria Info PH. Also YouTube. Just search for Nigeria Info PH on YouTube. And via Facebook, Bright is a goes. I personally applaud Governor Wike for this milestone achievement, as it is a win for all states, for all Nigerian states. All right, Ralph Razole goes. These people are making us to be confused. Well, maybe there are efforts, Ralph, to cause some confusion, but from the submissions of my guest and others, there really isn't much. It doesn't seem like there's much of a confusion at all. Or is there, Barrister? Is there any confusion at all?
There is no confusion.
All right. And via WhatsApp, Dio, we have seen court remove sitting governors from office. They still remain as governor once they appeal the matter till it gets to the Supreme Court. If FIRS has appealed the case, they will be the ones collecting tax. The Supreme Court says otherwise. That's from Obina. Obina, are you making a statement or a question? But Barrister, I'd like for you to respond to this.
Obina is wrong. The Electoral Act provides that when there are contestations, the person in office should remain until the matter is exhausted at the Supreme Court. That is only with respect to the Electoral Act and electoral matters, so it's not applicable to other matters. An appeal does not operate as a stay of execution, and it does not alter the judgment in other civil matters until there is something to the contrary, like a judgment to the contrary, or an order of stay of execution, either by the court that made the judge that gave the judgment, or by the appellate court pending the hearing of the appeal. So, in the absence of such order, the last judgment is the law.
All right, Mina from Elemi, I believe Barrister Wokocha's comments just now answers your question as well. But here's the question via WhatsApp. Hello, Dan. A transmission of record of appeal cannot act as a stay or does not translate to a stay of execution. The states are entitled to VAT until the existing judgment is overturned. Okay, Mina was not asking the question, she's making a statement. It's great to hear from you. So the phone lines now, Egbay from Rumokoro, you're welcome. Please go on.
Yeah, I want to ask the man on the studio this question.
Go ahead.
The matter, as you just rightly said now, is not exhausted yet. Why is the governor so much in a hurry to collect this tax? From the news I heard and the announcement we had this afternoon, he said it's meeting with the stakeholders of all these business, private individuals, and all those people that do business in the state on Wednesday. And I think if I may presume, to save us all some time, there is a judgment of court that grants River State the right to collect the VAT. So it doesn't have much to do with whether the governor is in a hurry or not. We have not exhausted all the avenues.
Once again, Egba, there's no other avenue. The court is the only avenue here, and the court has said River State has the right to collect VAT. And there's no other judgment.
Court to the court of River State.
Now, once again, Egba, there is no an appeal does not serve as a stay of execution in law. Do you understand that?
According to you.
It's not according to me, Egba. It's according to the law. Okay. Leko for Rukboko, you're welcome. Please go on.
Thank you, Dio.
Yes.
I think there's no confusion in this case. It's very straightforward. There is a valid and substantive judgment of the Federal High Court. The Federal Inland Revenue Service application for stay of execution was dismissed in its entirety. The appeal to the Court of Appeal by the Federal Inland Revenue Service against the said judgment by Section 17 of the Court of Appeal Act does not apply as a stay. The case of TSA Industry Limited and against Kamal Investment Limited, reported in 2006 through Nigerian Widow Report, Part 6964, 300, at page 300 is very clear. So the directive by the Federal Inland Revenue is unconstitutional. They shouldn't subvert the letters and spirit of the Constitution. So Rivers State have the right to collect the value-added tax. Thank you, Dayo.
Okay. Barrister, the position of the FIRS insisting that businesses or individuals still remit the VAT to the FIRS, does that constitute a breach of the law or even contempt of court? And can they be held liable for that?
It's irresponsible and contemptuous. What they are saying here, although you can say, okay, they are saying we have filed something which we are hopeful that the court will add to. To that extent, we can say it's not contemptuous because they are asking them to join them in being hopeful. Otherwise, it's irresponsible of them when the court has spoken for them to by themselves reverse the position of the court. As I said earlier, if what they were saying we are true, then it wouldn't have been necessary for them to file a motion for self-execution as well as the appeal that they have filed. So they are contradicting themselves and they are being irresponsible as a government agency.
Well, Henry from Transomali, welcome. Please go on.
Yeah, good evening.
Go ahead.
Does this look like true federalism is about to play out in Nigeria through the likes of Governor Wike. Honestly, Dayo, I was going through the news also last night, and I think I like what is going on now because this seems like true federalism, that states that have facilities and develop their states can produce and then pay. Because in Kano, if I was telling me this afternoon, Harry, they're not allowed to drink beer here in Kano, but beer is produced here in the south. And then when they drink beer here in the south, and then they generate revenue, VAT is paid to federal government, and all of that happens. Doesn't this sound like what we've been agitating for so many years? I think. Look, there are the beneficiaries of this whole thing now. It's not even River State. Ogun State has so many factories. Lagos State.
No, that River State is not going to be the biggest beneficiary. Lagos State is going to be the biggest beneficiary. I think Lagos State accounts for about 50 to 55% of total VAT collected.
This is what we need. They are the ones who benefit. So you see, our governors, our warriors, those who are educating us, the likes of my Wokocha, that great guy. I honestly thank you. Your advisor there is a fantastic man. People should look into our laws and begin to look at the things that will make us to be practicing true federalism. This is a very good development. For this state now, there's gold there. I was watching one of the sister stations on television. They are discovering mineral resources and all of that. We should generate our revenues here and pay tax to the federal government as due. This is the way to go, Zion. Other than that, anyone who is against this kind of practice, I mean, it doesn't love Nigeria. We can't continue the way in the trajectory, like Prof said. Well done there.
All right. Emmanuel from Wokocha, hi, go ahead.
Yeah.
Hello, Emmanuel from Wokocha, go ahead, please.
Yes, good evening. Yeah. I want to use this opportunity to thank Professor Wokocha for his fairness in telling us about the position of the law. And I've been following him from time to time, each time he invites him on. And he has been very vocal to tell us the position of the law, without playing ethnicity or religious dichotomy. But, hello, Adayo.
Yeah, go on, Emmanuel.
Yeah, but telling us exactly what the law is. And I thank him so much and want to encourage him to continue to give out those legal precedents.
Emmanuel, great to hear from you. Thanks. We appreciate your kind words as well. Now, via WhatsApp, hello, I will contend that if a court decided that VAT is not a reserve of the federal government, shouldn't the right course of action be to pronounce it as null and void? VAT was borne by a federal law, and the rate determined based on certain criteria. How then can a state simply co-opt a tax they never conceptualized? If any state must collect VAT, they should not just adopt the rate from the new voided VAT Act. They need to convince stakeholders before they can fix any rate. Barrister, your take on that? It's an interesting question that this person has asked, because the VAT was not a creation of the state in the first place. So how do you go to court, to the courts, to ask for the right to collect something that did not emanate from you at all?
No, you don't have to have created it. It's enough that it exists and it's an infraction on your right. The challenge is to the existing law, which was unconstitutional, and they were successful. But they cannot collect the VAT by themselves unless they impose it by a law, which is why they have enacted the law imposing the tax. You recall you asked that question concerning states that do not have the law, and I said what it simply means is companies are for now going to enjoy relief from that taxation until the states impose them by law, because the tax is an imposition which must be done by a law, a valid law. So there is nothing wrong with what has happened. There was an existing law that was an infraction on the rights of states, and the state challenged it. The brain challenge is non-existing thing. But it recognized that it cannot by itself collect it unless it has a law on it. That is why it has enacted the law, which Lagos State is also following now to do, and other states will do.
Right, and via WhatsApp, good evening, I think that the position of FIRS is contemptuous, and whoever is urging businesses to ignore a subsisting court judgment may be liable to commit a proceedings. Yes, Oyemai Squire said that. Hello, John from Monica, you're welcome. Please go on.
Hello?
John from Monica, go ahead with the comment or question, please. Go ahead.
Are you hearing me?
Go ahead, John.
Okay. Yeah, I want to thank Barrister Wokocha on issue of this awareness. I will say is information that a lot of us and some of our lawyers cannot even help us to challenge. For instance, the issue of Nigeria practicing two laws in the constitution, Sharia law and the other part. Why can't we challenge it in the court? Is it correct? Is it correct or is it not wrong for us to be practicing that kind of, when you're a Muslim, you go under Sharia law and other part of the country. What of other people who are not Christian or who are not Muslims? On what basis was the constitution formulated? Is it on religious basis or what? We need to be clear so that people can know and all these things can bring the proper information and then a true federalism can practice in this country. Thank you.
You're welcome, John. Via WhatsApp still, there was a comment, a question that I wanted to... All right, good dial. Please, could the well-respected barrister tell us if states can ask for VAT proceeds deducted from states by the FGN in the course of the years gone by, saying it was unconstitutional? Newton sent that in.
That's a long one. Can the states do so? A state can ask, but again, another thing to consider is that a law once enacted is valid until it is declared invalid. So it will mean possibly that why the law was valid and why there was no conflict, because there was no conflicting law in the state imposing that tax to enable them collect that tax. So why there was no conflict by way of a conflicting law, that law would have been valid until it was pronounced invalid. So this invalidity will take effect from when it was pronounced invalid.
All right. We've got George from Burikiri. Hello, George. You're welcome. Go ahead.
Dayo, good evening.
All right, go on.
Yes, what we are hearing is federal state. Can the local government chairman also go to court and challenge how to collect their VAT in the local government? Is it possible? Or this is only for the state and the federal? I said, let me ask this question so the lawyer can.
All right, George. Barrister?
Local government can only collect what is mentioned for them. They can only act on matters that are mentioned in Section 9 of the Constitution, Section 7 of the Constitution, which talks of local government rights or powers. So they cannot legislate on VAT. They cannot impose VAT. It's a residual matter which the state legislature has competence to make. It's not one that is listed under Section 7, which provides for powers of the local government.
All right. Hello, Chikudi from Umusi. Welcome. Go ahead.
Hello, Dayo.
Hello, go ahead, please.
Yeah, just like you said, we know this case is going to the appellate court. From there, it's eventually going to get to the Supreme Court. I know FIRS will not rest till. The question is, if he gets to help me ask I hope our learned is listening.
Yeah, he can hear you.
Gets to the Supreme Court, and the Supreme Court rules in favor of the state. What else can the federal government do? Because I know they are not going to sleep. This is not going to go down well with them. In what other way can they go to reverse this whole process? Are they going to go through the National Assembly, or there will have to be some other form of constitutional amendment, or the Supreme Court judgment becomes a law or what? For those of us who are not legally inclined or so. Thank you.
All right, Shukran. So, Barrister, if the Supreme Court grants the prayers of the state, Rivers State, can the federal government still thwart this process? Is there an ace of their sleeves they can pull out at any time?
As is severely said, they can only appeal to God with respect to that particular question over which the Supreme Court has made a pronouncement. But can they do something else? Can they refer to the legislature? That is at my level. If they can get the National Assembly to amend the Constitution and properly bring in VAT within things that they can handle or that they should handle exclusively, if they can do so, which will also require that 2/3 of the states of the Federation will agree with that proposal in that constitutional amendment bill before it can go through. if they can succeed in doing that, yes, you can change anything by changing the constitution or the provisions of the constitution with respect to that thing. But until you succeed in doing so, if the Supreme Court pronounces the matter is dead, the only way you can resume or resurrect the matter is to make a constitutional amendment, changing, which means from that day, from the day that the constitution is amended, you are changing the position of the law that the Supreme Court has pronounced on.
But how easy would that be for the federal government, considering that constitutional amendments?
It will not be easy because it will require the concurrence of the states, and the states are the ones who are saying you are wrong, and it's our right that is at stake. So they will certainly not get 2/3 of the House of Assembly of States to approve that constitutional amendment before that law can go into effect, before it can be passed by the national legislature. Once it does not achieve up to 2/3 approval of the House of Assembly of States in Nigeria, it will not go back to the National Assembly for them to vote to approve it before sending for assent. It dies at that point. So it's unlikely to happen should it come to that, because it will require the states giving up that right that they have just recovered before it can happen.
All right, stay back to WhatsApp right now. What is the work of FIRS in the state? If the states say they're the ones who have power to collect VAT, let them know that all federal roads is to be maintained by the states. If the states are to collect VAT, no justification for any government to worry federal government for maintenance of federal roads, because it's the collection of VAT federal government is getting money to maintain federal roads. Let everybody know that if the states collect VAT, that state should maintain federal roads, not federal government again. That's from Thomas. Is that going to be a likely outcome, Barrister, Thomas's position?
Very, very funny. That collection has nothing to do with road maintenance. There are several taxes federal government is collecting and are going to continue to collect. There are federal workers in every state. There are federal secretariats and federal ministers in every state. And there are other issues relating to companies and companies' income tax, for instance. All of those are federal government collections. VAT is just one of several taxes that the federal government collects, and it will not do them any harm.
And by the way, a lot has been said about VAT, and we're just focusing on VAT. I mean, I think that the judgment of the Federal High Court and Port Harcourt also stated that beyond VAT, the state also has the right to collect personal income tax as well. And I think, isn't that as critical as VAT? Or I suppose there's a lot of attention on VAT, and no one's talking about the personal income tax as such.
Yeah, I haven't seen the text of the judgment with respect to enabling me comment on that part. But the issue that was before the court was the VAT. Any other thing that is said by a court that is not part of the core question raised before that court is said obiter. By that we mean it is said as an aside. It's not part of the core resolution of the question that was posed before it. But of course, the state governments are entitled to personal income tax. As at more at the moment, they have been collecting personal income tax of workers in the state that are not federal workers. For federal workers, the police and the federal agents, whether it's police, army, and all those ones are collected by the FIRS, by the federal government. All others that are not federal service are collected by the state.
All right, we've got Charles from Go, I think. Hello, Charles. Welcome. Go on.
Yeah, good evening, Gaio.
Hello, go ahead.
Please, after the problem will be in computation, like crude oil extracted from the states, then recharge cards that you normally load will be telecom. How would they be paying the states now?
The same way they were paying the federal government.
But how will they know the exact people that is recharging in each state?
The same way they know how many people have mobile phones in River State right now. The same way they know how much data has been consumed in River State. If you want them to break it down for you, local government by local government, I'm sure they can do that.
But crude oil, there will be a problem.
How would there be a problem?
When they don't know exact crude, barrel quantity of crude oil they normally take from these states.
Well, if proceeds from crude will form a part of VAT that states should collect, whatever methods are used in collating what's paid to the federal government right now will be used in collating what will be paid to the states as well. All right, Charles, great to hear from you as well. We are drawing to the close of this conversation. We're via WhatsApp. Let's see. Good evening. We believe the state of Nigeria are directly responsible for the security and welfare of the people and properties within its territorial space. The state should directly be in charge of taxes and VAT. Look at what is going on in Benue, other troubled states. The people know only the governor, and the federal has in one way or the other exempted herself from these troubled states, claiming the governor and local leaders should sit up and act. Diet Wike is right this time. That's Frank from Woji. Itari Dukwe goes, VAT judgment maintains status quo. The FIR should tell us what the status quo is. I hope they're not planning to disobey the court judgment, because that's the status quo as of now. If the FIRS wins the appeal, will taxpayers be mandated to pay the same VAT paid to River State to FIRS again? And that's from Timitokwe. I asked that earlier on. I hope you caught it. The barrister simply explained to that way to be formulated that whatever amount was paid to the state, whether River State or any other state, will be remitted to the federal government, of course, via the FIRS. Manowski says, I may not be a lawyer to have understood that as at today, River State government is the right party to collect VAT with the judgment of the River State High Court. Until this judgment is being set aside by the appeal or Supreme Court, River State government is responsible for VAT, not FIRS. It's as clear as that. Ibube Jonathan from Ikodi says the judgment is so clear on the matter. FIRS has lost it for now, so that they don't have any right to force any company to pay VAT to them. As it stands now, there is no law backing FIRS for collecting VAT from River State, because you don't bring out an offence where there is no law. Even though the federal government is backing FIRS, the law is set to be supreme till a higher court says otherwise. It's as clear as that. Barrister, what do you see playing out in the coming days and weeks? Not as regards the courts or what the courts will decide. We'll leave the courts to decide that. But I'm aware, as a previous caller also mentioned, the River State government has called for a meeting with heads of businesses operating within the state. I think that meeting is for tomorrow. What do you see playing out in the coming days?
Well, they are going to sensitize those heads of businesses and formally bring to their attention, beyond the news items, they are going to formally bring to their attention the facts of the new legal position and direct them to do what they are required to do by the value-added tax law of the state. They will encourage them to act immediately, and maybe if there are any difficulties those ones will have, it will be an opportunity for both parties to clarify facts and streamline things to enable the new position of the law to take up fully.
On that note, to wrap up the conversation, thanks to joining, especially my guest, Barrister Ritchard Wokocha, is a former chairman, Nigeria Bar Association Assoc branch, also associate professor of public law at the River State University. Barrister Wokocha, thank you for your time.
Always a good day.
Go for commercial break right